we first kind of got involved in this case with an entity called Progeny, which is an entity in Wichita that serves previously incarcerated youth. And Kansas Appleseed had a relationship with Progeny already. In fact, we under Bennett's administration, we'd actually helped set that organization up. And so they started talking to us about a number of their members, young people who were having issues with this being on the gang database, and the kind of harassment they were getting, constant pretextual stops, the fact that they couldn't get off. They had a young man who had been trying for years to get off of the list and was not able to do that because there wasn't any procedure for that to happen. And they also had concerns about meetings that they were having, because one of the criteria is if you are seen associating with somebody who's a gang member, that can mean you're a gang member as well. So let's say Progeny is organizing a protest and people are coming to the protest. Well, if someone at the protest is designated as a gang member and a bunch of people are hanging out with them, it's very possible those people will be then designated as gang members. So for all these reasons, we thought it was really, really important to bring this case. And we also thought that the disparity in how it was being applied was pretty stark. As you may not be surprised, by far the majority of the folks who are on that gang list are Black and brown people. Very few people who are white, even though Wichita has several entities like the Proud Boys and Oath Keepers and stuff like that. They don't seem to pop up on this gang list. So we decided that it was necessary to bring this challenge. And I'll go through some of the criteria. I just really briefly want to list some of the criteria the police can use to say that you're a gang member. And I won't go through all of them, but some of the ones that they have to have 3 out of these 10. If you meet 3 out of these 10, an individual law enforcement officer can put you on the gang list as a member of a criminal street gang. So you are in effect being designated as a criminal based on one law officer's application of these criteria, and they don't have to give you notice, and there's no way to get off, no way to challenge your inclusion or get off that list. So you can see the problem right there. So here's some of the criteria. Let's see, frequency of particular street gangs area. No designation of what those areas are. And in discovery, the Wichita Police Department admitted that they don't really know. That's kind of a moving target. Wherever they think gang members are, well, that's where you shouldn't be, but you don't know that because you don't know what they're thinking. Adopts a gang style of dress, color, use of hand signs or tattoos. That again is, entirely up to the police as to whether they think your tattoo is a gang tattoo, or if you're wearing red. We had one individual who was renewed on the list because he was wearing in a Facebook post a red Philadelphia Phillies hat, and that was their reason for re-upping him on the gang list as an active member. If you associate with known criminal street gang members, and that means, and associates isn't described, so what does that mean? And we had police officers say, well, if you're hanging out on the porch with them, or if you're at a concert with them, or any of those kinds of things, that can be enough to say that you yourself are a gang member just because somebody else who you're around is on their list as well. If you've been arrested more than once in the company of identified street gang members, and then they have, if you're identified as a street gang member by physical evidence, including but not limited to photographs or other documentation. And that one, again, they comb Facebook, they look for, for things where people are like throwing signs, doing whatever, and boom, that can be enough. That's physical documentation that you're a gang member, even if you haven't done anything to warrant being called a criminal. And then been stopped in the company of known criminal street gang members 2 or more times. And that's if you're riding in a car and the car gets stopped and they say, well, somebody in the car is a gang member, well, then everybody else who's in the car is associating with the gang member. And, the real issue with this is you can be put on the list and designated as a member of a criminal street gang. you don't even have to be charged with anything. You don't have to have any charges. You don't have to have undertaken any criminal activity. In fact, we had a couple of our class reps who, when they were put on the list, had absolutely no criminal activity, no juvenile activity, no nothing. But yet they were called members of the criminal street gang. So we brought the statute because we heard about the issue from Progeny. So back in 2020, prior to filing the lawsuit, Kansas Appleseed had a summer justice fellow, and we asked our justice fellow to do some really in-depth research about this, about the constitutionality of the practices, and also to look around the country and other places to see what other challenges had been there. And of course, I think that there was the LA, I think at the time or right around then, there was a big challenge to the LA gang list where they had, babies on the list, all those kinds of things. We knew there'd been a challenge in Chicago. So we did some really in-depth research about, what would be possible and whether it would be possible to bring a case. And then having decided that we were really interested in doing that, we partnered with the ACLU of Kansas. I'm the only full-time lawyer at Kansas Appleseed, so we need partners always to do this kind of work. So we partnered with the ACLU of Kansas and with a wonderful pro bono firm, Shakardi and Bacon, who was our pro bono law firm on this case, and just did amazing amounts of work for us, and helped us pay for experts, helped us with discovery, that kind of thing. So one of the first things we did after we decided we were going to file this lawsuit, we talked to Progeny about being a class rep. They're our organizational class rep because they could talk about the damages to their members and to the curtailment of their activities that they had to undertake. And we also talked, and we also asked them to help us find individual class members. And so we identified 4 people who were on the gang list for various reasons and under various circumstances. And who agreed to be our class representatives. And this wasn't easy because, this is a risk for these folks. They're on the gang list in Wichita and they're already targeted. And so, this can make them even bigger targets. And we also had to find people who were really interested in, in changing things for the community and understanding that we're bringing a case that's trying to get injunctive relief, not damages for them. So these folks are understanding that they're not going to get any personal compensation for the things that have happened to them from being on the gang list. That they're interested in making changes going forward. But we found 4 really good class reps. We filed a very extensive CORA request, which is the Kansas Open Records Act, for those of you not from Kansas, to get some more information from the police. And then based on that, in April, we filed a class action, and we alleged violations of the 14th Amendment for vagueness, procedural due process, substantive due process, and equal protection, and under the First Amendment for violation of the freedom of speech and association. And as you can, we filed in federal court in the District of Kansas, and the first thing that the defendants did, as one would expect, is to file a motion to dismiss. We did survive the motion to dismiss. We had two of our claims dismissed without prejudice. That was the Equal Protection Act and our Substantive Due Process Act, because they said we did not have the kind of particular information this particular court thought we needed to bring those causes of action. After we had done discovery, we felt like we could have asked to amend the complaint, especially to get the equal protection claim back in. But because we thought we had really strong evidence of the other claims that we already had, and all we need to win on is one claim to get the injunctive relief, we made the decision not to try to reamend, not to try to bring those claims back through amendment, but to stick with the claims that we had, because we felt that we developed really strong proof on those claims, particularly the violation of the freedom of association and the procedural due process claims, which, when you don't have notice and there's no way to get off, if you're wrongfully designated and you're called a criminal, that's a pretty damning issue and pretty damaging. So we went through discovery. Fortunately, our pro bono partner Chicardi helped us with document organization. They were generous enough to allow us licenses on their relativity, which is a really robust case management document organization program. And we had, we had probably well over 100,000, a couple 100,000 documents. So lots of documents. We took about 25 depositions, including a couple of expert depositions. The discovery was robust, let's put it that way, and kind of fun. I'll have to admit, I like discovery. I like taking depositions, so it was kind of fun. But long story short, we survived the consequent motion for summary judgment that defendants brought. We filed our own summary judgment because I always think strategically, even if you don't think you're going to win a summary judgment motion, if you have a colorable claim, colorable belief that it's possible you could win it, and the other side's going to file a summary judgment motion, you're better off to file your summary judgment motion, because it's likely that the court will just say, I'm not going to grant anybody summary judgment motion. And that's indeed what happened in this case. We also briefed class certification, and we did get class certification. The court granted our class cert motion. So we now have a class, and we are scheduled for trial in early May. So looking forward to that, and lots of work getting ready for that. Along the way, we have had some mediation, and we have made some progress on some things. There is still a last gasp chance to mediate, to get this case done through mediation. So we'll know that probably within the next couple of weeks, but we're still going ahead and preparing for trial. And if, and what we're asking for the court to say the statute's unconstitutional, the policy's unconstitutional, and either get rid of it or make them totally rewrite it in order to get, to make it sane, to make it real, to make it tied to actual criminal street gang crimes. You can't be put on the list unless you are, unless you've been adjudicated like a criminal, and that the crime that you're charged with is not just selling dope on the street by yourself, but a crime that inures to the benefit of the gang, because that's what we believe the criminal street gang should be. If it's used at all, it should be reserved for, for people who are really using a criminal entity to further crimes as a group. And frankly, I think that's a lot less present than it used to be. I mean, some of this is kind of hangover from the 90s, right? Or even the 80s, where you had these gangs who kind of had a hierarchy, and they were more like a mob, right? But, that's not so prevalent anymore. And most of these things that they call, gangs are just crimes and, people who commit crimes, not necessarily street gangs.